I'm about to summarize the judgments of the Supreme Court in an appeal by Mrs. Elgizouli against a decision of the Court of Appeal. But before saying anything about the appeal itself, I must mention the obvious fact that the judgment is being delivered remotely. Indeed, this is the first judgment of the court to be delivered in this way. And of course, as everyone will realize, the reason that it is taking place like this is because of the COVID-19 pandemic. Obviously, it would be preferable that the judgment be delivered in open court, but in the present circumstances, that is simply not feasible. The working practices of the court have had to be adjusted so that we comply with public health guidance and to minimize the risk of COVID-19 to court staff and users. It is a fortunate circumstance that in this day and age, it is possible to function effectively as a court by means of technology. And the court is determined that with the enormous help and dedication of our IT staff, we will continue to discharge our duty in the administration of justice. Mrs. Elgizouli is the mother of a young man called Shafi al-Sheikh. The appellant's son is alleged to be one of a group of terrorists operating in Syria, and that he was involved in the murder of United States and British citizens. In June 2015, the United States made what is known as a mutual legal assistance request to the United Kingdom, and that was in relation to an investigation into the activities of the group of which Mr. al-Sheikh is alleged to have been a member. And the request related to evidence held by British authorities about the activities of Mr. al-Sheikh and Mr. Kuti. When this request was received, as was customary, the Home Secretary sought an assurance that the information would not be used directly or indirectly in a prosecution that could lead to the imposition of the death penalty. The United States refused to provide that assurance. After many exchanges between British and US authorities, in June 2018, the Home Secretary agreed to provide the information to the United States without requiring any assurance whatever. Mrs. Elgizouli challenged the Home Secretary's decision. The two principal issues were, one, whether it is unlawful under the common law for the Secretary of State to provide mutual legal assistance in the form of evidence to a foreign state that might facilitate the imposition of the death penalty without having obtained the type of assurance which the Home Secretary had sought. And the second issue is whether it is lawful under Part 3 of the Data Protection Act 2018 to transfer personal data to law enforcement authorities abroad for use in capital criminal proceedings. The Court of Appeal dismissed the appellant's claim on both grounds, and she has appealed to this court. The Supreme Court unanimously allows the appeal on the second ground. I shall deal with that ground first. And much of the information provided or to be provided to the US authorities consisted of personal data. It was common ground between the parties. The provision of mutual legal assistance involved the processing of such personal data falling within Part 3 of the Data Protection Act. Such processing is only lawful where it complies with the data protection principles, which are set out in Section 34 of the Act. I concluded that since the transfer of material to the US authorities without obtaining death penalty assurances was contrary to law, it followed that the first and second principles, which required that processing be lawful and fair, were not met. And furthermore, Section 73 of the Data Protection Act provides that a transfer of personal data to a third country is only lawful if it is based on what is called an adequacy decision or on there being appropriate safeguards or in special circumstances. Here, there was no adequacy decision and no appropriate safeguards. Transfer on the basis of special circumstances can only occur following an assessment of what is strictly necessary. Such an assessment had not been made. On that account also, I consider that the transfer of the material was in breach of the Data Protection Act. In Lord Carnwath's judgment, with which the other justices agreed, he also noted that there was no adequacy decision as required by Section 73, and he observed that for the operation of the special circumstances gateway, specific consideration by the relevant controller of the statutory tests, including the test of necessity, was required. The information in question, said Lord Carnwath, was transferred without being based on sufficient safeguards and without the requisite assessment of whether special circumstances justifying the transfer existed. And in his view, the decision was based on political expediency rather than strict necessity under the statutory criteria. It was therefore unlawful under the Data Protection Act. On the first ground, I, alone among the justices, considered that the appellant should succeed. I noted the steadfast opposition by successive United Kingdom governments to the imposition of the death penalty in any circumstances, and the related long-standing policy not to provide mutual legal assistance unless death penalty assurances were received. I observed that the common law was not immutable, but that it develops over time to reflect the changing values of society, and that law must be responsive to society's contemporary needs, standards, and values, which are in a state of constant change. That is an essential part of the human condition and experience. I concluded, therefore, that a common law principle should be recognized whereby it is deemed unlawful to facilitate the trial of any individual in a foreign country, where to do so would put that person in peril of being executed. This principle should only be disapplied, in my view, if mutual legal assistance is absolutely necessary as a matter of urgency in order to save lives or to protect the nation's security. The other justices who comprised the panel were unable to share my view on the common law. The reasons for considering that the common law had not developed as far as I had suggested it had were explained by Lord Reid and Lord Carnwath. Lord Carnwath found that the power of the courts to develop the common law must be exercised with caution. The death penalty, he said, as such, has never attracted the attention of the common law. The key legal developments have come from Parliament and the European Convention on Human Rights, not from the domestic courts. One recent development he referred to is Section 16 of the Crime Overseas Production Orders Act of 2019. This section confirms, first, that this is an area in which Parliament remains directly involved, and secondly, that where the Act applies, there is nothing that specifically prohibits the Home Secretary from exchanging material in cases whether they have been sought but have not received, where they have been sought but have not received assurances that the information they exchange will not be used to facilitate the death penalty. This, according to Lord Carnwath, suggests that the common law has not developed as suggested by me. Lord Reid agreed with Lord Carnwath for the reasons given in his judgment and for additional reasons. Lord Reid found that the common law is subject to judicial development, but that such development must build incrementally on existing principles. This is necessary to, firstly, preserve legal certainty, and secondly, ensure compatibility with the preeminent constitutional role of Parliament in making new law. The development of the law proposed by me did not appear to Lord Reid to be an incremental step. In the event, however, the appeal is allowed on the second ground of challenge. Thank you.